Ridgefield Inland Wetlands Board. IW 2419. 27 Abbott Avenue. Public hearing. October 10, 2024.
And this is the regularly scheduled Town of Ridgefield Inland Wetlands Board meeting for Thursday, October 10, 2024. In attendance, we have Alan Pilch, Carson Fincham, David Smith, Isaac Flatto, and we have staff members Artie Paranjape and Caleb Johnson. And we have first on the agenda, continued public hearing for IW 24-19, 27 Abbott Avenue, plenary ruling application for the construction of 10 residential townhouses with associated drainage and landscaping within the upland review area of wetlands and watercourses. Owner Vitan Alimi, applicant Brian Carey. And I believe we have new documents to read into the record, or a list of them.
Yep. Okay, we have Brian Carey resume, Brian Carey professional wetland scientist certificate, public hearing extension letter dated September 26, 2024, Anthony Zembo resume, resolution of denial, 27 Abbott Avenue, IW 23-18, SLR peer review comments dated September 26, 2024, Land Tech response to public hearing comments dated October 8th, 2024, Andy Sumilidis resume, Ridgefield Affordable Housing Inventory dated October 9th, 2024, Ridgefield, Connecticut listings, and SLR peer review comments dated October 10th, 2024.
Thank you very much. Okay, in terms of where we are in the schedule, we did get an extension from the applicant last time. If we were to close the public hearing today, we would have 35 days to render a decision, and that would be November 14th, which happens to be the same day as a meeting. So technically we have 2 meetings unless we did a special meeting. Okay, so I guess the applicant should start first, and in terms of answering any final questions, going through your final list of questions and answers, be very helpful.
Good evening, Brian Carey with Land Tech Engineering out of Ridgefield, Connecticut, for the applicant, Vitan Alimi. Thank you again for having us. I'm going to keep my comments short. We tried to get everything into the record as soon as we possibly could. We were responding just to a couple things that had been submitted. But mostly what had been submitted since the last meeting was just really stuff to clean up the record as far as putting in our resumes. That being said, we did receive comments, final comments from SLR, and we submitted a document addressing those final comments. Those are in the record. They were put in the record. We did get a response from SLR that was added into the record today, basically just stating that we had satisfied all their comments and that they had no further questions and were in agreement with where the plans have set, basically where the plans are at this point. The same is for Artel Engineering. They did put their comments into the record. Jay Klein, who's with me, and Andy Sumilidis, who's also with me. We can address any comments or questions that you may have, but we hope to close the hearing tonight and basically give our final, not rebuttal, but final closing marks, which we are ready to present.
Okay. Before we go any further, Tim Bishop's having some trouble. He didn't get a link. Caleb, can you send him one?
Yeah, I just sent him one.
Thank you. Very good. So they should be here momentarily. Before we go further, are there any board members who had questions after reading the latest list of answers that the applicant sent us? At the moment, not seeing anything. Okay. Any questions from our peer reviewers? I believe we have Michelle from SLR here. And she did send a letter, but she agreed to be here if there were any further questions. No questions. Okay, I didn't have any. Then I guess we could go over to the intervener. I believe we have Catherine Brown in attendance.
Tim Bishop finally log in. Thank you.
Okay. It's good. Catherine, are you ready?
Yes, I'm here.
Good.
Just so you know, I filed a memo late today, not till after 4. I did send copies to the town council and applicants council, but I don't know if it's been posted or if anybody else has it. I'll just summarize it briefly. It pretty much has everything I wanted to say, except for one point I left out of the memo. I noticed that today they posted some affordable housing statistics on the website, or that was submitted by the applicant. I assume there's no narrative. So I wanted to just briefly address that issue. Number one, which I did not put in my memo. The Affordable Housing Law 8-30G is not what governs this board. I'm sure everyone's aware of that. It's under Title 8, which is a zoning law. Title 22A governs this board. And that should be a full stop. The wetlands statute does not provide for a balancing test of the needs for affordable housing versus the need to protect wetlands. Those are two things that are not specifically stated in my memo, but if the hearing is closing tonight, I'd just as soon go through the salient portions of my memo so you have it in front of you. The first point I'm making is I'm going to request that the board incorporate 2023-18, which is last year's application, into this record for a couple reasons. It's been referred to multiple times. Everybody remembers it was only a year ago. A lot of the existing site conditions are described explicitly in that one a year ago. And it's actually, this hearing now, my understanding is more or less a settlement discussion, even though it's a new application. The court appeal, which I have intervened into, is being delayed or suspended or rescheduled, a number of scheduling milestones based on this hearing here. So the two are related, and I would ask that that hearing record be incorporated into this for that reason. Just relating to the stormwater system, it's still inadequate. Everything, it has changed since 2023. It was scaled back, but it was not scaled back enough. So it does not solve the problems that are inherent in the stormwater system. It still has significant regulated activity and structures within the 100-foot upland review area, including manholes, detention infrastructure, dumpster enclosure, dumpster walkways, driveway, handicap parking space, and an elevation of the land by about 3 feet, as well as a retaining wall. There will, of course, be added road salts because public safety, especially of a handicapped driver and people using the dumpster, are very, very important. So I would expect added dissolved toxins to be within the regulated area. I'm not going to go through what our engineering expert said, just his conclusion that this is not LID at all. And by tacking on a rain garden without adequate testing or space does not make it LID. It will not adequately cleanse the water before it ends up in the wetland offsite. The wetlands are critically important, especially in this very dense part of town. You just don't have wetlands of this quality in such a developed area of town, which makes it even more important that it be preserved. It supports 2 listed species, which we have presented evidence of. And finally, feasible and prudent alternatives exist. We have an existing permit to build a triplex on the property, which only would take up 15%, I built approximately, impervious surface on the approximate just under half-acre site, whereas this one is upwards of 60%, close to 2/3, and that makes a difference. Just talking about other properties that have been developed way before these regulations, it's just not relevant. Just because historically we did not follow today's practices does not mean we need to continue doing that. So I don't think it's a relevant comparison, aside from the fact that there is nothing greater than a triplex on any of the neighboring properties, and certainly none of them have 10 units with the associated cars and pollutants that would be generated. I just want to address affordable housing. I don't know why these information was posted. There doesn't seem to be a narrative. But again, the affordable housing law that I think they're relying on is 8-30G. That does not govern this board at all. I've done a lot of research. I'm on the zoning commission in Fairfield. I've done a lot of research on 8-30G. That 10% ratio is not a target. It's not a goal. It's an exemption. And when the 8-30G law was passed over 35 years ago, certain large cities and poor towns were exempt because that's where there was a lot of poverty, and that's where the government had built a lot of affordable housing, housing projects. Those were exempted because they already had well over 10%. Other towns that had their own maybe senior and disabled housing and a very small percent government run, those towns are never going to get to 10%. We've been told in our town, it's never going to happen. It's almost impossible to make that up. So the 10% ratio should not be a guidepost on which anyone should judge the progress of this town to add affordable units. The ratio is also flawed in numerous ways. It basically says how much affordable housing you have as a percentage of your total housing stock. And you have somewhere under, between 2 and 3%. A lot of the suburbs do. And that's often used as a way of saying you're not doing enough. Well, as I pointed out before, if you started out with all the housing projects and other towns didn't, it's almost impossible to get up there without adding hundreds or thousands of units of affordable without building anything else. That's not going to happen. But secondly, the ratio itself is flawed. It has, it includes Section 8 housing vouchers and CHAFA down payment assistance loans, both of which are outside of a town's control and can fluctuate up or down. Now, I noted in one of the charts they gave you tonight that was submitted, it shows that your ratio has gone down. Well, you have to question, why would a ratio go down? We're not destroying affordable housing, we're adding it. The ratio, though, is affordable to total. And the affordable can actually go down if people stop using as many Section 8 housing vouchers in your town, which you can't really control. Also, housing vouchers are pretty much doled out to some of the big cities. Towns don't get very many. You have no control over it. So my point being, the numerator of that ratio includes things out of your control and things that can make your ratio fluctuate up or down. The final point about that is, as you get 8-30G developments in, only 30% of the units have to be affordable. That's how they get around all the zoning laws. That's the quid pro quo of that law. But when you're only adding 30% affordable, you're adding 70% unaffordable. So that will only very, very minor addition to the ratio based on that. You could almost never reach the 10% by adding only 30% out of the total and adding 70% to the denominator of that ratio. So I'm not very good at math, but that's my calculation. It's just never going to happen. The final thing is, I was looking at your affordable housing plan, which all towns have had to do for the last couple of years. You have an affordable housing plan from 2022. And in your plan, you point out that something which I've discovered also, which is naturally occurring affordable housing is not counted in this ratio. This ratio is an 8-30G ratio. Really, you should be considering all kinds of affordable housing, whether or not it qualifies under 8-30G. Naturally occurring affordable housing can include duplexes, triplexes, which just naturally rent for lower rates. And according to your own affordable housing plan from 2022, calculations made using 2018 data suggest that if naturally occurring affordable housing were to be counted under 8-30G, the town could claim 12% of the units as affordable. This could represent as many as 1,000 additional units that do not qualify under 8-30G. So my point of all this discussion is, I don't know why these statistics were put up there. The ratio should not be used. It's irrational. It's unreasonable. It fluctuates up or down. You have to question it. Over 80% of all towns in the state have never reached 10% and never will. And it's pretty much the same 131 or so towns. And only about 38 or so of our 169 municipalities have reached it. And those are generally the same 39 that had it in 1989 when this law was passed. There's a reason why the needle is not moving. The ratio doesn't make sense. It should never be used by any board, court, or commission to judge a town's progress. The fact is you are adding units, and that ratio should not be used to judge you harshly.
Okay.
None of this is really relevant. That's my
Yeah,
point.
no, that's what I mean. I wonder where you're
not
going
relevant.
with this, because it's not relevant.
I'm talking about it only because I think you have to put it in the record. I've seen court cases where judges actually talk about it, and it's not relevant. It's not relevant, and it shouldn't be used. So that's really my point. The bottom line is you have a mission, and that is to carry out the very specific goal of protecting these wetlands, which will be adversely impacted by this design on this site. The testing was not adequate to support LID, and it's not LID. And based on that and the added toxins and the inadequacy of the stormwater system, it will adversely affect this wetland. And that is the very specific goal of this board. A generalized thought process that we need more affordable housing cannot be used to balance that. And there is no balancing test in the wetlands law. There's no balancing test required. So it shouldn't be balanced, but just in case it's invading this hearing, I wanted to point all of those points out. And that's really all I had to say about that. If there's any questions, I can supply more information.
Okay, thank you. Do we have any members of the public who wish to speak? I didn't see any hands up. I think we've,
I have
all
one
read.
hand. I'm gonna allow.
okay, yeah, we've all had the chance to read the correspondence. Okay. Mr. Carr?
Yes, thank you very much. Kirk Carr, 62 Prospect Ridge for the record. I just wanted to say, I think it was September 12th, the meeting that you had. At the end, Mr. Samolides launched an attack against Mr. Trinkhouse, saying that he was a self-proclaimed LID master. And that was extremely unprofessional. It was not called for. It was inappropriate. It was not on the topic, talking about other things that Mr. Trinkhouse has worked on, which he couldn't defend, and you wouldn't want to take the time to defend them. So that was, I mean, I think that Mr. Simulidis should be admonished on that point. And certainly what Ms. Braun just brought up, the 830G issue, it's clear that the applicants' attorneys and representatives are throwing whatever they can against the wall to see what sticks, whether it's on topic or off topic. And that's a tremendous waste of your time. And you should really be aware that, you know, they're clearly desperate to try to get this thing through, and they'll do or say just about anything to do it. Thank you for letting me speak.
Thank you. We have Mr. West, it looks like, next. Hello, Mr. West, are you there?
Can you hear me all right?
Yes, we can.
Okay. Hello, I'm John West. I live at 16 Abbott Avenue. 130 years ago, the land east of Abbott Avenue was swampy and used as a town dump site. The area was eventually abandoned and filled. The house presently located at 27 Abbott Avenue, built in 1951, was once owned by a family named Costanzi. Nearly the entire yard was nurtured into a magnificent vegetable garden, producing extraordinary produce, most likely because the site was bathed in sunlight and the ground stayed moist. Knowing the site's history, I don't think the ground would be conducive of absorbing great quantities of water. But I'm not a soil engineer, and the developer has engineers that have designed a system that will curtail flooding or wetland damage resulting from this development. They say it will work. Another qualified engineer said it will not. Even Mr. Verbekis stated with respect to this type of system, over time, something will happen. The question I will ask again is, what statement of responsibility will the developer offer if the system fails? The other question I will ask again is about snow plowing and or removal and melt management. The only proposition I see offered is a ludicrous plan to put 80 cubic yards of snow, that would be from a 12-inch snowfall, between the building and the street. I find it hard to believe the developer thinks this would be plausible, much less the turmoil that would be caused on the street while hauling it away from this location. On several occasions, various members of Mr. Alini's team have cited that all the surrounding properties are within IWB buffer zone, suggesting that this sets a precedent in the area. There was no buffer zone when that land was developed. There is now. The relevance does not exist. And Ballard Green and Victoria Gate runoff is collected into Ridgefield's stormwater system. Landtech presented some past stormwater projects associated with Mr. Trinkus, seemingly questioning his expertise. I wonder what juicy tidbits somebody might uncover with a deep dive into Landtech's past projects. The information from both would be irrelevant and wholly out of context with this proposal. They have also.
Thank you. I'm sorry, have you finished?
Am I supposed to be finished?
Well, yeah, we're trying not to go over 3 minutes or so.
Okay.
So if you could finish, that'd be great.
That's fine. You want me to finish? That's the end then, I guess.
Oh, if you had anything else, you could, as long as it's quick.
Well, no, that's fine. You cut me off.
I appreciate that. Thank you very much.
I don't appreciate it.
Well, I'm sorry, Mr. West. I thought you actually were finished and then realized you were not.
Okay.
And I did offer you the chance to finish. I'm sorry. I didn't mean to offend.
Continue.
I'm sorry?
Tell her you're done.
I'm done.
Oh, okay. Thank you. I think Elizabeth Seaman is next.
Hi, can you all hear me?
We can.
Okay, thank you. I'm actually standing outside and looking at the Northern Lights. So everybody get out there and look at it later tonight. My name is Elizabeth Zeman. I live at 2 Abbott Avenue on the corner of Abbott and Gilbert. I've lived there for 27 years. I'm a licensed practicing architect. My husband is a licensed practicing civil structural engineer. We've followed all the hearings. There's so many things I could say, but I guess the thing that is weighing on me the most is that I just don't understand why we have neighbors at the where the stream comes down and crosses Gilbert Street, and they are reporting that repeatedly and more often their homes and their property is getting damaged and flooded by the overloaded stream. So why are we considering or possibly considering approving a project that's going to add all this impervious surface and going to add all this runoff to a system and is going to overload the drainage system even more and cause even more damage downstream to our neighbors? I just think that's an unfair burden to put on our neighbors. I'm also really concerned about the amount of site disturbance. Right now, we're building an addition on my house. The net square footage that's being disturbed is 300 square feet. And the amount of dirt and rocks that have had to be dug out and piled on the site is enormous. And all my neighbors have been to it will tell you. So when I consider this project probably being about 10 times that size, I just don't understand physically, as an architect, someone who works in construction, how this project is going to be completed in such a way that doesn't spill over for months, the neighboring properties and disturb that much earth. Okay, my time's up. Thank you.
Thank you. Do we have any others?
No. Oh, there's one more.
I'm sorry? Okay, one more.
Yes, one more.
Ms. Castellano? Oh, Castelluccio, sorry.
Yes, hello, can you hear me?
Yes, we can.
I'm sorry, I'm in a car. I am a resident at 32 Abbott Avenue, directly across from this property, and I've been a resident for 25 years. I had brought this up before, and I think I've heard of solutions, but I just want to state again that the removal of snow, I can tell you where it's going to go, because the house right next to that house, which has the main house with the 3 units, their snow gets plowed straight out onto my lawn. So I'm just saying, you can come up with all these plans of what should happen. And I know they have to have like snow removal, but I could tell you where that snow is going to be removed. It's going to be pushed right out to the home across the street and my home. So I just wanted to mention that again. And again, even what Liz just mentioned with the construction at her site, just the amount of cars that even were across the street for the last week because someone is moving into the house, 27 Abbott, it's just impossible to move around, and it's pretty dangerous, but I think that's more for zoning. So thank you.
Thank you. Do we have any others?
Yes, I see 2. Now Deborah can talk.
Okay, thank you.
Hi, thanks. Henry, okay.
Yes.
Hi, I'm just here to ask about the qualifications of the environmental scientist, because I read that recently he was indicted for illegal dumping in Fairfield, Connecticut. So I'm questioning whether we can trust his opinion on anything he has to do with the project. Is that clear? Was it clear on that? Sorry. Was he clear on that?
I'm sorry?
Was it clear on that? Was it clear?
Yes, yes, your comments are clear.
Okay, thank you. I just ordering this person to drive the train on this project, which has severe environmental issues. And given his past history, I don't feel like we should be listening to his advice. Just my opinion. Thank you.
Thank you very much. We have at least one more. Oops. Trisha Gala.
Hi, my name is Patricia Gala. I live at 3 Abbott Avenue. I'm one of the residents that has the stream behind my house. Although I'm on a little bit of a sloped elevation above grade from my other neighbors, I believe that in time, my house will experience the same kind of flooding that my other 2 or 3 neighbors behind me and next door to me have experienced. And it is really important that this needs to get figured out. In addition to that, in the front of our house, we have, so I'm being inundated with water in the back and the front. There are only 2 drains on Abbott Avenue, and all of it flows south. And it goes and it creates this crazy flooding in the front of both my house and the house directly across from me. So I'm not sure if this is part of that impervious surfaces issue that we keep talking about, but this needs to be addressed as well. That's all I have to say.
Thank you.
I see no more hands.
Thank you, Artie. Any other comments, questions from board members? We're going to close the hearing. We have to make sure all our questions have been asked at this point. Okay. Then I think we could ask the applicant to do a closing statement or whatever else.
Sorry, I was just pulling this back up. So, again, I just want to start off by saying thank you to the board. I know this has been a long process, not just once, but twice, but we've outlined a project that is environmentally sound, that is needed in the community, that is well cited on the site, that has been reviewed by several experts, not only our team, but also the third-party reviewers for the town, not just once, but twice, and has received recommendations, not necessarily approving it, but finding that there was no adverse impact to the wetlands or wildlife. SLR has submitted comments into the record saying that they've been satisfied with the review of our plans. We've taken those comments from SLR and Artel and have addressed those comments. We've listened to the comments of the public. We've listened to the comments of the board. We've routinely changed the plans to address comments by the public, by the board, and by the third-party consultants, whether it was warranted for an environmental purpose or not. So I just wanted to go through the PowerPoint real quick, just to give a background. A lot of what has been said, not just by the public, but also by the intervener, is speculation. Mrs. Braun has said perfectly, talking about the wetlands and the quality of the wetlands. Unfortunately, the intervener did not provide any evidence into the record regarding the quality of the wetlands. We have reviewed the wetlands and have submitted information detailing our study of the offsite wetlands and those impacts which have been mitigated from the property. So to go through this very quickly, again, I just want to, give reference to the system we are talking about. The wetland is a stream course that is surrounded by a highly urbanized area. You can see that the density on the site and the proposed density is not outside of the context for the neighborhood. It's in keeping with context of the neighborhood. The site is serviced by sewer and municipal water, making it available for this type of development. As you can see, we've overlaid the plans onto the aerial photography showing how the area is being protected. We previously listened to the denial, obviously, from the commission, and we integrated all of those comments that we heard during the last application period. And we did our best to add all of those comments and address all those comments in the development of this existing site plan. Again, you can see the limited stretch of the wetland that is located directly off-site of the property to the east. Just to go back and say, how did we get here? The applicant purchased the property about 2 years ago. There was an approved, and there is an approved plan in place from 2018. We did try to go pull building permits for this plan, but we were told that because there was no drainage approved as part of the inland wetland application, that we would need to go back to inland wetlands because we weren't able to pull a zoning permit or a building permit. So this plan, which was approved, you can see is more impactful, and this is an approval. It's only 20 feet away from the wetland. There's much more density and development within the upland review area, and there is no mitigation plantings. So even though this is approved, it's much more impactful to the wetland system. Moving forward, we did come back that we were in front of you in 2023 with a denser plan of 14 units. We still think that this provides adequate buffer and stormwater retention so that there is no impacts to the wetland. That being said, the commission denied the application, and the applicant, as you know, has appealed that decision, which is pending. Moving, you can see, I'm just going to go through real quick. You can see the previous approval. That being said, this is our current alternative, which again has been reviewed by SLR and Artel, and all of the comments from the previous denial and from the commission have basically been incorporated into the existing plan. You can see the density of the riparian buffer and how it's been changed over time to address the comments of the commission. While we do think that the 2023 plan is also protective of wetlands, this plan is even more protective of wetlands and is basically a direction that was provided us by the commission. So this is just a quick summary of all of the comments that were previously stated on the different plans. I just wanted to touch on some points that were brought up by SLR and Artel and things that we have done to supplement the plans to make them even more environmental friendly. SLR had suggested to increase the amount of low impact development based on the project, which we have done. We did add a rain garden as a tertiary treatment mechanism that will drain off the level spreader. So basically our treatment train has got 4 different levels. One of them obviously being first the Coltech system that will then discharge to the level spreader into the rain garden and then flow over the native riparian planting buffer. I just want to state again, there are no wetland impacts. My professional opinion as a soil scientist and professional in the industry for over 25 years is that there are no impacts to the wetlands being proposed as part of this application. There are no on-site wetlands. The only wetlands that are a part of this application are located directly off-site to the eastern property line. We have mitigated the possibility of any erosion or sediment getting into the adjacent wetland by standard erosion and sediment control measures that are recommended by the state of Connecticut in their soil management guidance document. And again, both Artel Engineering and SLR, the third-party consultants for the town of Ridgefield that were hired by the commission, have reviewed these plans and have both agreed that there are no impacts to the wetlands. There's been a lot of talk about wildlife. Some of it being entered into the record has been speculative. We've done numerous NDDB requests to the state, and we have found no record in the state that there is any salamander, blue-spotted salamander, living in that area. The people who have put forth that issue are not experts in this field and are not able to make that determination. We do agree that there's a box turtle on site that has not been seen on site by us, but that is listed in the NDDB database. But our standard sediment erosion controls and the other mitigations that have been built in the project will protect against any impact to the box turtle during the construction process. After the construction process, the location of the wall will prevent the turtle from moving into upgraded parts of the site, which is a mitigation component of the request of the NDDB filing. So just to go through, basically to talk about, and again, I know that this is a separate standalone application, but we just want to go through and discuss how we have complied with the previous denial that was issued for the project. And I don't know if Jay Klein would like to step in here.
Mr. Klein?
Sure, I'd be happy to do that. For the record, my name is Jay Klein, attorney with Carmody, Torrance, Sandak, and Hennessy, partner in our real estate group, and here tonight on behalf of the property owner. I think kind of taking a step back in some of the comments that Brian had, he accurately and correctly pointed out, I think as we all know, this is not just the continuation of a public hearing, but the continuation of a conversation that has been going on for the better part of a year, and it started with the application. that we brought before you in 2023, and it carries us into this evening. Some might say, gee, that's a long time to be talking about one piece of property, but it may be that this conversation, this back and forth is exactly how the wetlands process was intended to be carried out. I think it was said earlier this evening that there is no role for balancing in your analysis. I don't like to read from statutes, but I am going to do it quickly. The enabling the first section of the Inland Wetlands Act states that the intention of the act is to balance the need for growth of the state and use of land with the need for protecting the environment. And so it is that balancing act that you all are really charged with achieving here this evening. I would say that these reasons for denial are relevant to the factors that you are charged with looking at in section 10 of your regulations. And this proposal, as modified throughout the course of this entire process, we believe is worthy of your approval. In terms of the environmental impacts that Brian mentioned, Mr. Verbickus couldn't have said it any clearer at the last meeting, right? He said, I don't see any impacts to the wetlands. His firm was entrusted to review this property not just once, but 2 times. So clearly someone that has earned the trust of the town, clearly someone who is an expert in his field, and endorsed the treatment frame that Land Tech designed and provided some comments throughout the review process that we adhered to, and so much so that Mr. Verdickus said, all of my comments have been satisfactorily addressed. SLR provided another independent perspective, and based on you all received some comments from them this evening, confirming that there were no outstanding issues for them to review. But in fact, 2 weeks ago, before our last session, there was an email received, and that's in the record, that said, we see no issue with closing the hearing 2 weeks ago. That may be because SLR recommended a couple of important environmental controls in this project. One of them being the rain garden that Brian Carey mentioned earlier today. But the other one was SLR's recommendation to place a conservation easement over the 75-foot buffer that we've established on the property. That's a conservation easement that will prohibit the development of that portion of the site in perpetuity. It will prohibit development of that portion of the site forever. And I don't know if there are any other properties on this stretch of Abbott Avenue, I don't know, that have this type of perpetual protection. And that's okay if they don't. That's okay if this is the first, and maybe this is the first step in the creation of a conservation corridor along the wetland. I want to say that the environmental impact, or lack thereof in this instance, is also relevant to the petition that you all received under section 22A-19 of the Connecticut General Statutes. And in order for a petition to be successful on the merits, they must prove that there is not just an impact on the environment, but an unreasonable impact on the environment. As the evidence makes clear, not just as presented by our experts, but by the experts that you have all retained and entrusted to review this in an independent fashion, there is no impact of any kind that is unreasonable or negative in any fashion. Brian discussed, and we're looking at, he's labeled this the alternative, and that's the next key question in the course of a wetlands analysis, and making that balance between growth and environmental protection. Feasible and prudent alternative question. There was a recent Connecticut Superior Court case that I think provided a pretty good example of what these words feasible and prudent really mean when you apply them. Case out of Fairfield Housing Corp versus the Fairfield Conservation Commission. And in that case, the judge, who's the Connecticut's land use judge, for lack of a better way of putting it, specializes in land use, wetlands, and zoning decisions, found that there were no feasible and prudent alternatives where an applicant had incorporated design alternatives recommended by a town's independent experts. I think it's a similar situation in the application before you. Not only did we incorporate or listen to, not just hear, but listen to the comments that you provided in your decision in 2023, but we heard, listened to, and incorporated several of the features that not just Artel recommended, but that SLR recommended. And part of getting to this alternative, which is the feasible and prudent alternative, was the applicant's decision to reduce the number of homes that we were proposing for this site. In doing so, we were able to triple the setback from the wetlands from 25 feet to 75 feet. And as Brian mentioned, that's 3 times more than the setback that was approved back in 2018. I'll again defer, and I believe Ms. Anto is here as well, defer to the independent experts that were entrusted by the town to review this, but none of them are recommending any additional alternatives to be considered at this time. We've adopted all the alternatives that they suggested that we incorporate. It is neither feasible, and for that reason, it's neither feasible nor prudent to provide any additional alternatives because no more are needed to avoid an adverse impact on the wetland. I will say, and I'm not going to read from the statute this time. There was a comment about how the need for housing the need for more affordable housing is entirely irrelevant to this application. Again, that's not true. The word prudent is defined as something that is economically or otherwise reasonable. I'm sorry, I'm reading from the statute, I lied. Economically and otherwise reasonable in light of the social benefit to be derived from the proposed regulated activity. And clearly, I think the socially the social benefits to be derived here are quite clear. Something else that was uploaded was an example of what a renter who wants to live in Ridgefield would experience if they were looking for an apartment to rent yesterday. When you log on to Zillow, you look for opportunities to rent in Ridgefield. There were only 12 options, many of them single-family homes, many of them multiples, thousands of dollars a month in rent. So it would be imprudent to deny the project for that reason. Your next standard has to do with short and long-term impacts on the wetlands. And Brian discussed it, and I'm sure Andy Soumalides is here, can go into greater detail on this, how construction, and Brian actually provided in his memo earlier, how the phasing plan that we're implementing, the regular reporting that we are more than willing to do, and monitoring both in the short term and the long term will address short-term impacts. In terms of irreversible harm, again, no evidence of this in the record, none identified by your experts. And in fact, the implementation of a conservation easement will lead to the opposite of irreversible harm, but perpetual protection of the environmental resource. There's no evidence on any issues that would lead to health or safety violations. And one last point on the conservation easement, I guess I would say, with the wildlife question, certainly a lush, effectively wooded area on the east side of our property is a better condition than just the lawn that's there today. I'll wrap up and hand the baton back to Brian and Andy. With this, we've heard the neighbors. We understand there's a concern, and we appreciate, as Brian said, and as we've said throughout this process, we appreciate their involvement through the course of these proceedings. And for those who are concerned, suggesting, should it be 6 apartments, should it be 3 apartments, those concerns will be heard fulsomely by your colleagues on the Planning and Zoning Commission. And we expect to see our neighbors when we are before the Planning and Zoning Commission as well. But when you look at the impact on the wetland, when you look at whether there'll be any environmental harm and the environmental impact in that nature, that question has been tested 3 times over in the course of this proceeding, not just by our professionals who wouldn't have put an application forward that didn't meet the standards, but by Artel Engineering and by SLR as well. Went through multiple rounds of comments from those experts, and all comments were satisfactorily addressed. Those recommendations, your comments on the 2023 application, have led to additional layers of wetland protections, ecological enhancements, and environmental conservation. And in approving this project, we will see, I think, meaningful progress on encouraging environmentally conscious development. We've made compromises in the plan that we originally proposed and the plan that we originally envisioned for this site. We've made compromises, and approving this project will not compromise the environmental integrity of the offsite wetlands. Thanks, Brian. Thank you.
Thank you. Sorry for jumping back off that quick. I had a frog in my throat, so I was about to start coughing, but I just will run through the last couple slides real quick. Just again, referring to how we changed the plan in response to the denial that was issued by the commission during the previous more intense application that was submitted. So one of the commission, obviously, one of the main reasons for the denial of the previous application was based on wetland protection, but also on the amount of buffer that was being provided under the previous plan. During that discussion with the commission, the denial that was issued referenced the 75-foot exclusionary buffer. We've done our best to address that issue. The only disturbance that will be created in the buffer area is a temporary disturbance, just in order to construct the rain garden, which was advised to us by SLR, but also to establish the riparian buffer, which will lead to a long-term benefit to protecting the wetlands. And again, Jay mentioned the conservation easement, which, if the commission recommends, will be placed over the area, also with a long-term habitat management program that will be that will run with the title of the land in perpetuity. The second reason the commission had some concerns about the stormwater management. We have addressed those comments by increasing the capacity of the stormwater system, but also adding layers to the system, that being the rain garden and also the more densely planted buffer. We do not agree with some of the conclusions that were reached by the third party or the interveners. Conclusions that the system will not work. All of the literature that we've reviewed and all of the text and guidance documents that we use in design during our design manual have been satisfied, and we are very confident that the system will function in a manner that will not only protect wetlands but also add to improvements of water quality coming off the site. Thermal impact was another condition, reason for denial. Again, we've established that riparian buffer and have also pulled the development back further 75 feet. We've provided many scientific literature citations within most of the information that we've provided. So everything we've entered into the record is backed up with scientific literature. Jay talked about feasible and prudent alternatives. We went through that earlier, but this process, although it's been long, has been a good example of going through feasible and prudent alternatives. We believe that the plan that is sitting in front of you, and again, I don't mean to sound like a broken record, has been reviewed and basically agreed upon by Artel and SLR. Does represent the most feasible and prudent alternative for development at this site. And with that being said, I know Andy Selmalides just had a couple things he wanted to say regarding just clearing up some of the stormwater issues, and then we can conclude our final statements.
Thank you.
Good evening. I know we're coming up on our hour, so I'll just be really quick. I think you've heard it through our closing statements that the stormwater will not only reduce for the necessary storm events up to the 100-year, but it would also provide the necessary water quality, flow, and volume as required by the 2024 Water Quality Manual in the state of Connecticut. But I'll just leave you guys with this last thought. Don't believe Land Tech. We were hired by the owner and developer of this site. Don't believe the neighbors, engineer, and experts, but believe your experts who you guys hired as being, completely clear vision in this and has really no agenda, right? No horse in the race. So I'll just leave you with that thought of these experts again, and you heard it and heard it and heard it again. But you have experts from Land Tech, your own experts, who clearly stated there will be no adverse impacts by the development of this proposal. Thank you all for your time and effort on this piece of property and application. And Brian, I don't know if you had anything else to close.
Yeah, I just wanted to say the last slide again, even the public, I know this was an emotional process, and I'm sorry about that. We did want to thank the commission and everyone there, regardless of the outcome. There's been a lot of time and effort spent in this process, and we do appreciate everyone's hard work. And that's all I have to say. So thank you very much.
Thank you. So at this point, I believe we're in a position, looks like we might have one more attendee with a hand up.
Yeah, I'll allow her to.
Thank you. Jacqueline, are you there?
Excuse me, I thought the applicant had the last word and we were done with public comment.
Well, we could let you comment to the comment if that's necessary. Okay. This will be the last, though. I
just didn't know we were going back and forth. No.
Well, no, someone had the hand up, and so we'll go ahead with this one. I don't know when the hand went up, to be honest.
Can you hear me?
We can.
Oh my God, I'm so sorry. So, I've been sitting here and watching these meetings all the way through, and I've been following a lot of planning and zoning and inland and wetlands and things like that. And I've listened to everybody, and I'm really so tired of hearing from this group that says there's no effect on the wetlands that we have adjacent to the property, the 27 Abbott property, and that it won't affect the flooding. As we sit here and watch the river going down our street already on Abbott Avenue. And then the thing that really bothers me is that I've been sitting here for, I don't know, a year and a half, and the person who's the applicant is actually a convicted felon who was found guilty of hazardous waste dumping in Fairfield, costing those taxpayers millions of dollars. Why would I believe anything that Land Tech says if that's who their representatives are? Why would I need to sit here and listen to that and believe anything they say? That's my question. So if you want to make a closing comment, you can comment on that.
Thank you very much.
Thank you.
If the applicant has a closing comment to the closing comment, then please go ahead. Otherwise, I will close the public hearing.
Well, I think to correct the record, there are no convicted felons on the team here. And as I think Mr. Sumalides and Mr. Carey and others put it, understand that this can be an emotional process. We understand that neighbors are invested in what goes on in their community. But you don't have to believe a word that we say or that Andy has said or Jay Klein has said. Trust the people that you've trusted to review this application. We hired our engineers last year to review our initial application. They retained your trust, and so they were retained again. SLR certainly doesn't suffer fools when it comes to the question of protecting wetlands and environmental resources. If there was a cause for concern, both of those firms would have said so. Both of those firms would have said as much, and both of those firms would have been here tonight saying, do not close this hearing or do not approve this application. But that's not the case. As I said, this has been a deliberative, thoughtful, extended process. And there's the comments that you just heard were just not accurate. As Andy said, believe your experts. Thank you very much.
Thank you. Okay, then. I believe we are in a position to close the public hearing, which is today, 10:10. And we will schedule the discussion to begin on 10:24. And there'll probably be some applications that are heard before we get to that discussion, just so you know. But we will put it on the next agenda. And as I mentioned earlier, we have actually until November 14th. So I want to thank everybody for all the time. Thank you to the neighborhood people for being very patient with the process. And that's about it for now. Thank you.
Thanks, everyone. Have a good evening.
Thank you.
This is Kirk Carr, on the record. Thank you for watching.